Yes, good morning.
Good morning. Good morning, Commissioner.
Now, what is your understanding of the doctrine of exhaustion of administrative remedies, and are there exceptions to the application of this doctrine?
Yes, the doctrine of exhaustion, Commissioner, posits that where the law provides for other remedies before a matter can be brought before the court, then a party is bound to first exhaust those remedies before then approaching the courts for determination. For example, in a case of, say, if it is a political issue and there's a provision for matters that are to be heard by the IEBC dispute resolution, is it committee or a board, or there are internal dispute resolution mechanisms within a political party, then those must first be exhausted before then a party can be able to approach a court or a tribunal to determine the same issues. And also another example is where there's a provision for arbitration, then a party has to go before an arbitral tribunal before then it can come before the court to determine the issues in question.
Are there exceptions to that doctrine?
Doctrine of exhaustion, I may need to look at that again. Yes.
Now, we have several agencies and institutions with powers to decide or sit on matters of disputes within their domain. However, we still find that all cases still go right to the judiciary.
Yes.
Most people don't go to these internal dispute resolution mechanisms or other administrative mechanisms. Why do you think that is so?
Sometimes it's because of, I would say, they are not conversant with what the law says. Sometimes people want to take shortcuts, and sometimes also there's a feeling of biasness or inability of those institutions to preside over the disputing issue. For example, maybe somebody feels as a member of a political party is not likely to get justice before the particular dispute resolution body of that political party, then they may by mistake rush to court to seek a resolution over the matter.
So what can we do to tell Kenyans that the courts cannot solve all their problems and there are other mechanisms that can sort out some problems or some issues or some disputes? Because everybody is of the view that the courts can solve all problems, whether legal or not.
It's a good thing when the public has confidence in the judiciary. And I think it's something that as an institution we ought to be proud of. However, we need to do more education, reach out to the public and let them know that in as much as they may have full confidence in the judiciary, the law also provides for other dispute resolution mechanisms. And if they take advantage of such, then they would help the courts to take care of the problem of backlog that is really.
But if you open the door too wide, there is an influx.
Yes.
And by the time you determine the cases and come to the conclusion that they ought not to have come to court, it will be 3, 4, 5, 10 years down the line.
Commissioner, if they are well educated and they get to be informed of what other avenues are available to them, be they AJS mechanisms, mediation, then definitely if those other mechanisms are also operating efficiently, then we'll be able to address that issue so that the general public will be able to take advantage of them.
Okay, thank you.
Welcome.